Hello, so I want to talk to you now about Chapter 6, and that's the role of government. I've chatted about the organization, ethics overall, business ethics, organizational ethics, and social corporate responsibility. When we talk about the role of government in the overall scheme of business ethics and what happens within organization, there are some key legislation that's been passed in order to kind of put some safeguards in place to help uh, guard organizations, people against corruption, against unethical acts. Some key legislation that you need to be aware of is the Foreign Current Practices Act of 1977. There's the U.S. Federal Sentencing Guidelines for Organizations, 1991, the Sarbanes-Oxley Act, well known right now in organizations, and that's probably what you will hear most of the corporate compliance officers talk to you about when you're talking to them about an ethical issue within their organization. So the Sarbanes-Oxley Act actually was put in place in 2002. You've heard more about it as you started to see some of the more recent scandals throughout the 20th century. And then you have the revised Federal Sentencing Guidelines for Organizations Act, and that was revised in 2004. And then you have something called the D-O-D-D, Frank Wall Street Reform and Consumer Protection Act of 2010. Let's start with the Foreign Corrupt Practices Act. This legislation was introduced to control bribery and other obvious forms of payment to foreign officials and politicians by Americans that held publicly traded companies. Now, prior to passing this law, the illegality of paying bribes was punishable through some type of secondary sources of legislation. The Security and Exchange Commission, the SEC, they could fine companies for failing to disclose such information as payments under its security rules. The Bank Secrecy Act required the full disclosure of funds that were taken out of or brought into the United States. And then there's something called the Mail Fraud Act that made the use of the U.S. mail or wire communications to transact a fraudulent scheme illegal. You would think that all of those were already in place, but I just want to kind of set the background for this. So let's continue with the Foreign Corrupt Practices Act. It is jointly enforced by the U.S. Department of Justice, the DOJ, as well as the SEC, the Security and Exchange Commission. It encompasses all the secondary measures that were currently in use to prohibit such behavior by focusing on the following: disclosure and prohibition. So when you think about disclosure, it's a requirement that corporations fully disclose any and all transactions conducted with foreign officials and with politicians. And prohibitions, it included the wording from the Bank Secrecy Act and the Mail Fraud Act to prevent the movement of funds overseas for the express purpose of conducting some type of fraudulent scheme. Now, the act has been criticized for lack of authority because of its formal recognition of facilitation payments. Now, facilitation payments, this is acceptable or legal, provided these facilitation payments, they are acceptable, or I should say legal, if they secure the performance of a routine governmental action. So routine governmental action is any regular administrative process, excluding any action taken by a foreign official in the decision to award a new or a continuing business some type of contract. If you look in your book, you'll see a figure in your book, and it's figure 6.1, and it shows illegal versus legal behaviors under the FCPA. So that should be helpful if you're trying to see, okay, now what's legal and what's not legal. Look at that chart that's in your book and you'll see what I'm talking about. Let's move on to the U.S. Sentencing Guidelines for Organizations Act of 1991. This act holds businesses liable for criminal acts of their employees and anybody that represents the business. And some of the penalties under the FSGO is there could be monetary fines, there could be organizational probation that's given, there could be an implementation of some type of operational program that'll bring the organization into compliance under the FSGO. When you think in terms of monetary fines under the FGSO, the process for calculating a fine is the fine is determined. It's determined by a couple of things. So let me explain a couple of those things. It looks at whether or not there was some type of monetary gain on behalf of the organization because of the offense. It also looks to see if the offense caused any type of loss to the organization or to people. And the amount is determined by a judge on the FSGO table. There's a culpability score that's applied too. Now, this is a calculation of a degree of blame or guilt that is used as a multiplier of up to 4 times the base fine. So it can be adjusted according to aggravating or mitigating circumstances. So monetary fine under aggravating. Let's talk about what aggravating factors may be, and let's talk about what mitigating factors may be. So aggravated could be where there's a higher level person, leader, personnel involved in, or they've tolerated the criminal activity, so they know all about it, they're a part of it, they've tolerated it. Aggravated could be where the organization, it willfully obstructed justice, or the organization had a prior history of some type of similar misconduct, or the current offense violated a judicial order, an injunction, or a condition of the probation that they've been placed under. Those are aggravating factors. Mitigating factors would be the organization had an effective program in place to prevent and detect any type of violations of law. The organization may have self-reported there was an offense. They went ahead and told government officials. They cooperated in an investigation, and they accepted responsibility for what had happened in this issue in the organization. When we talk about fines that are given under the FGSO, there's something called a death penalty. It's not what you think it is, but there's a determining final amount, and that score is the base score that's multiplied by that culpability score that I calculated a few minutes ago. So death penalty is a fine that is set so high that it is detrimental to the organization, and it could actually drive the organization out of business. And it's warranted where the organization was operating for a criminal purpose totally. When you hear terms like organizational probation, this is when organizations, they could be sentenced up to 5 years of probation. The requirements for the status of probation sometimes can be that the organization would have to report their business's financial condition, and they have to report it to the court on a periodic basis. The remaining subject to unannounced examinations of all financial records by the designated probation officer and accorded chronic experts. So this is a requirement too, or could be something that could be a part of the organization being put on probation. There could be a process where they have to report the progress of the implementation of their compliance program. And they could be subject to unannounced examinations that will confirm that what they say they're doing in their compliance program is indeed being accomplished, and moreover that it is working. There are some steps to think about when we think about a compliance program. Those steps are management oversight, corporate policies, communication to the organization of the standards and procedures, compliance with standards and procedures, delegation of substantial discretionary authority, consistent discipline, and response and corrective action. These are steps that are put in place in order for you to develop a compliance program. Now remember, I talked about the FSGO, and I said that it was introduced in 1991, but it was revised in 2004. Here are some of the key changes to the FSGO. It requires companies to periodically evaluate the effectiveness of their compliance programs on the assumption of a substantial risk that any program is capable of failing. It also requires that there's some type of revised guidelines that are required, and those revised guidelines must be evident that is actively promoting ethical conduct within the organization rather than just complying with what the legal obligations are. I want to get to the Sarbanes-Oxley Act 2002. This legislation was a response to all of those corporate accounting scandals of the early 2000s. That this act covers financial management of the business, and it contains 11 sections relating to prominent examples of corporate wrongdoing. Public company accounting oversight board is a part of this process. It's where there's an independent oversight board that audits the company. Then you have the auditor independence, corporate responsibility, enhanced financial disclosures. There's an analysis to see if there's a conflict of interest, commission resources and authority. There's study and reports, and there's corporate and criminal fraud accountability. All of these pieces are part of the Sarbanes-Oxley. White-collar crime penalty enhancements, corporate tax returns, corporate fraud and accountability. Now, as I bring this to a close, just remember that SOX, that's what Sarbanes-Oxley Act is, SOX, that's how it's referred to. It does not help create an ethical corporate culture, nor does it hire an effective and ethical board of directors. That is the job of the leadership of the organization. So that's the end of Chapter 6 and corporate governance and some of the laws that will impact whether or not put safeguards in place that help organizations do a better job at protecting the assets of the company and the employees. So thanks for being a part of Chapter 6, and I'll see you over in Chapter 7.